Margot Voss set the folder down on the breakfast table beside his coffee, and the sound it made, soft and final against the marble, was the only sound in the room for a long moment. Nathaniel looked up from his tablet, saw the word divorce printed across the top page, and did something Margot had spent 11 months preparing herself to survive without flinching at. He smiled. "Finally," he said, reaching for his pen without even reading the first paragraph. "I was starting to think you'd never work up the nerve." He signed it in front of her, unhurried, almost cheerful, sliding the pages back across the table like he was closing a minor real estate transaction, rather than ending a 19-year marriage. What Nathaniel Voss did not know, sitting there in his own kitchen congratulating himself on a clean escape, was that he had just triggered a clause buried 9 layers deep in a property deed older than their entire company. A clause that would strip him of everything he believed he'd built with his own 2 hands within the span of 30 days. He thought he was walking away with an empire. He was actually walking away from the only thing that had ever legally allowed that empire to exist. Welcome back. Before we get into tonight's story, tell me where you're watching from and drop a like if you love a slow burn reveal that lands harder than a shouting match ever could. This one is a masterclass in exactly that. Let's get into it. To understand what Nathaniel Voss lost the moment he picked up that pen, you have to go back 31 years, to a crumbling stone manor on 80 acres of Hudson Valley farmland that had absolutely nothing to do with hotels, luxury brands, or the empire it would eventually become. Windermere Manor had belonged to the Delacroix family for 4 generations, a graceful, half-ruined estate that Margot's grandmother, Josephine Delacroix, had refused to sell even during the leanest years of the family's fortunes, when every accountant and every distant cousin insisted the land was worth more as a subdivision than as a crumbling house nobody could afford to heat properly. Josephine held on to it anyway, out of a stubbornness Margot would only fully understand decades later, and when she died, she left the entire property to her granddaughter with one specific, deliberately worded condition written directly into the deed itself. A condition that meant almost nothing to anyone at the time it was drafted, and would come to mean absolutely everything 22 years later. The property could never be sold outright. It could be leased, developed, even transformed entirely, but ownership of the land and the manor itself had to remain in the direct Delacroix bloodline, held in trust for whoever carried that name forward, unless that heir formally, irrevocably transferred it during their own lifetime. An act Josephine's own lawyer had structured to require a level of deliberate paperwork almost nobody would stumble into by accident. Margot was 24 when she inherited Windermere, freshly out of a hospitality management program at Cornell, with more ambition than capital and absolutely no interest in selling off her grandmother's land for a developer's quick payout. She had spent childhood summers at Windermere, watching her grandmother manage the estate's slow decline with a stubborn, patient grace that never once looked like weakness, no matter how many relatives insisted the old woman was simply too sentimental to see reason. Josephine had taught her granddaughter how to read a roofline for water damage before she'd taught her how to drive, how to negotiate with contractors who assumed a woman alone wouldn't know a fair estimate from a swindle, how to hold something valuable quietly, without ever needing to announce its worth to anyone who hadn't earned the right to know it. "They'll always underestimate what you're actually holding," Josephine told her once, the summer before she died, sitting on the same back terrace that would, decades later, host Margot's own quiet conversations with her son. "Let them. It's the safest place in the world to keep something precious, inside someone else's assumption that it doesn't matter." Margot met Nathaniel Voss that same year, at a real estate conference in Manhattan. A sharp, magnetic young hotelier with big ideas and almost no money of his own to fund them. The kind of man who could sell a bank on a vision using nothing but confidence and a well-tailored suit. He was captivated by her immediately, not just by Margot herself, though he genuinely was, but by the manner she casually mentioned over their second dinner together. 80 acres of untouched Hudson Valley land with a Gilded Age house sitting on it, inherited free and clear. Nathaniel, who had spent 3 years pitching investors on a boutique hospitality concept nobody would fund, because he had no property to anchor it to, understood within minutes of hearing about Windermere that he had just found something considerably more valuable than romance. He never said that out loud, not then, not for years. But Margot, looking back on those early conversations decades later with the clarity that only comes from watching a person fully reveal themselves, would come to recognize exactly which parts of his early courtship had been genuine, and which parts had been calculated the moment he learned what she owned. They married 2 years later, and Windermere became the flagship property of what would eventually grow into Voss Hospitality Group, a chain of 12 boutique luxury properties across 3 states, built almost entirely on the reputation and design language established by that first, painstakingly restored manor house. Nathaniel ran the business side with genuine skill. Margot would never deny him that, negotiating financing, courting investors, building the brand's reputation in glossy travel magazines with a relentless, tireless energy that turned a crumbling family estate into the anchor of a genuine hospitality empire within a decade. But the land itself, the actual deed to Windermere Manor and its 80 acres, never transferred to the company. Margot's grandmother's condition had made an outright sale legally complicated enough that even Nathaniel's aggressive lawyers, reviewing the structure in the company's early years, had recommended the simplest workaround. Voss Hospitality Group would hold a long-term operating lease on the property, structured as a standard commercial arrangement, while the underlying land and the manor house itself remained titled in Margot's name. Marcus Whitfield smirked. Right there at the plaintiff's table, in front of a packed courtroom, in front of his soon-to-be ex-wife's tear-streaked face, he actually smirked, and leaned over to his attorney to whisper 5 words that would haunt him for the rest of his life. She never saw it coming. He was right in a way. Claire Whitfield hadn't seen the verdict coming. Not really. Not after 8 months of watching Marcus's legal team dismantle her credibility piece by piece in front of a judge who seemed to enjoy every minute of it. What Marcus didn't see coming, standing there straightening his tie and accepting congratulatory handshakes from his own lawyers, was the sound of the courtroom's heavy oak doors creaking open exactly 4 minutes after the judge finished reading his ruling, and the sight of an 83-year-old woman walking down the center aisle in a wool coat far too warm for the season, holding a leather folder against her chest like it was the only thing keeping her upright. Nobody in that courtroom, least of all Marcus Whitfield, understood yet that the woman walking toward the bench was about to make every single word of that ruling completely, legally meaningless. Welcome back. Before we dive in, tell me where you're watching from tonight. And if you love a reveal that arrives exactly when the villain thinks he's already won, hit that like button right now, because tonight's story delivers exactly that. Let's get into it. To understand what walked through those courtroom doors that afternoon, you have to go back 3 years, to a modest but comfortable colonial house in a quiet suburb outside Richmond, Virginia, where an elderly woman named Eleanor Kessler had spent the final winter of her long, careful life trying to solve a problem that had nothing to do with money and everything to do with the granddaughter she loved more than anyone else on earth. Eleanor Kessler had built, over the course of 6 decades, a modest fortune that most people who knew her would never have guessed existed. She and her late husband, Walter, had opened a small hardware store in 1962 with almost nothing, a few $1,000s borrowed against Walter's father's farm equipment, and a storefront they could barely afford the rent on. And through decades of careful, unglamorous discipline, patient reinvestment, and a refusal to ever live beyond what the business could genuinely support, they had grown that single store into a regional chain of 11 locations before Walter passed away and Eleanor sold the company outright to a national retailer for a sum that, even after taxes, left her quietly, comfortably wealthy in a way almost nobody in her ordinary suburban neighborhood ever suspected. Walter had died slowly, over the course of a difficult year, and Eleanor had nursed him through most of it herself. A season of her life that taught her, more thoroughly than any business lesson ever had, exactly what genuine devotion actually looked like up close, stripped of performance, stripped of any audience to impress. She had watched, in those final months, which of their old business associates and social acquaintances showed up with casseroles and quiet company, and which simply stopped calling once Walter could no longer be useful to them in any conversation worth having. It left her, in her widowhood, with a sharpened, almost instinctive radar for the difference between people who loved genuinely and people who performed affection only for as long as it served them. A radar she would come to rely on more than she ever expected. Sitting across a kitchen table from her granddaughter's new fiancé a decade later, she lived simply anyway, out of habit more than necessity, clipping coupons at 81 years old, not because she needed to save the money, but because 6 decades of building something from nothing had worn certain habits into her so deeply they'd become part of who she was. Her only real indulgence was her granddaughter, Claire, the daughter of Eleanor's son, who had died in a car accident when Claire was just 19, leaving Eleanor as the closest thing to a parent Claire had left in the world beyond her own grieving mother, who had moved across the country not long after to be closer to her own siblings. Eleanor had watched Claire grow into a thoughtful, hard-working young woman, watched her put herself through nursing school with a combination of scholarships and exhausting part-time work, and watched her, at 26, fall for a charming, ambitious young commercial real estate broker named Marcus Whitfield with a smile that Eleanor, even in those early days, found herself trusting rather less than everyone else at the wedding seemed to. "He's very charming, dear," Eleanor told Claire gently, a week before the wedding, sitting together at Eleanor's kitchen table over tea neither of them had touched. "I only worry that charming men sometimes save their real face for the people they don't need to charm anymore." Claire had laughed it off at the time. The easy laugh of a woman deeply, genuinely in love. Certain her grandmother's caution came from an old woman's natural wariness, rather than any real insight into the man she was about to marry. Eleanor didn't push the point further, but she made a quiet decision that same week, one she never mentioned to Claire at all. A decision born from 6 decades of watching people, of reading exactly the kind of confidence that curdles into cruelty once it stops needing to perform for an audience. She revised her will. The original document, drafted years earlier when Claire was still in nursing school and marriage wasn't yet on the horizon, had simply left the bulk of Eleanor's estate to Claire outright, the way any grandmothers will naturally would. The revised version, drafted quietly with an estate attorney Eleanor had used for decades and trusted completely, added a single carefully worded provision that would mean almost nothing if Claire's marriage turned out exactly as happily as everyone at the wedding hoped, and would mean absolutely everything if it didn't. The provision established a protective trust, structured specifically to activate under one narrow, deliberately chosen circumstance. Should Claire ever divorce, the entirety of Eleanor's estate, previously slated for direct inheritance, would instead transfer immediately into an irrevocable trust naming Claire as sole beneficiary, structured under Virginia law in a way that placed those assets entirely outside the reach of marital property division, protected from any claim her spouse might otherwise make during divorce proceedings, regardless of how the marital estate itself was ultimately divided. It was, Eleanor's attorney told her at the time, an unusually specific provision for a will, the kind of clause more common in prenuptial agreements than inheritance documents. Eleanor had simply nodded and told him she'd spent 60 years in business learning that the people who needed protecting rarely knew they needed it, until it was almost too late to arrange. She never told Claire any of this. She filed the revised will away, mentioned it to no one beyond her attorney, and continued clipping coupons and hosting Sunday dinners as though nothing at all had changed, carrying a quiet, careful insurance policy for a granddaughter who had no idea it existed. For the first 4 years of the marriage, it seemed mercifully like a precaution Eleanor would never need to think about again. Marcus built a genuinely successful career in commercial real estate. Claire continued working as a pediatric nurse at a hospital she loved, and the two of them appeared, from the outside, like exactly the kind of comfortable, ordinary happy couple Eleanor found herself hoping, against her own earlier instincts, that she'd simply misjudged. The cracks began in the 5th year, the way they so often do, quietly at first. Marcus's career accelerated dramatically after he landed a handful of major commercial deals that transformed him, almost overnight, from a solidly successful broker into one of the most sought-after names in the region's commercial real estate scene. And with that acceleration came a shift in how he spoke about Claire, subtle at first, the kind of small dismissive comment easy to excuse individually, and much harder to excuse once they'd accumulated into an unmistakable pattern. He began describing her nursing career, once something he'd claimed to admire deeply, as just a job. In conversations with his increasingly wealthy new social circle, he stopped inviting her to client dinners, explaining, when she asked, that the conversations were too industry-specific for her to really follow, though the wives and girlfriends of his colleagues, considerably less accomplished than Claire in any objective sense, attended those same dinners without any apparent difficulty following along at all. Eleanor watched all of this unfold from a careful distance during Sunday dinners, watching her granddaughter grow quieter, watching Marcus interrupt her with increasing frequency, watching the easy, laughing young woman from that wedding slowly fold herself smaller to fit into a marriage that seemed to require less and less of the person she actually was. Eleanor said nothing directly, not wanting to insert herself into a marriage Claire still, visibly, wanted to believe in, but she began, quietly, updating her attorney on the details of what she was observing, a habit that felt, to her, less like gossip and more like keeping careful watch over an investment she'd made a long time ago and never stopped monitoring. The marriage ended not with a single dramatic betrayal, but with a slow accumulation of smaller ones that finally, in its 8th year, reached a breaking point. Claire discovered, going through a jacket pocket while doing laundry, a hotel receipt for a night Marcus had told her he was in Charlotte for a closing that, as it turned out, had actually closed the previous week. She sat on the edge of their bed for nearly an hour that evening, the receipt held in both hands, running through 8 years of small, explainable absences that suddenly, all at once, refused to explain themselves the same easy way anymore. The late nights that had crept steadily earlier into the afternoon. The phone he'd started angling away from her at dinner. The way he'd stopped asking about her shifts at the hospital, not out of any single cruel moment, but through a slow erosion of curiosity she'd told herself, for longer than she wanted to admit, was simply the natural rhythm of a long marriage rather than the early architecture of an exit. The affair, when it fully surfaced, involved a junior associate at Marcus's own firm named Ashley Bourne, a woman 15 years younger than Claire. And it had, according to messages Claire eventually found on a laptop Marcus had carelessly left logged in one Saturday morning, been going on for the better part of a year, conducted with a casual confidence that suggested Marcus had stopped believing, at some point long before Claire ever found that receipt, that there would be any real consequence to discovering it. Claire filed for divorce 3 weeks after that discovery, exhausted, heartbroken, and for the first time in years absolutely certain of something. What she did not expect, what genuinely blindsided her despite 8 years of watching Marcus's ambition sharpen into something considerably colder, was the scale of the legal assault that followed. Marcus hired David Corwin, a divorce attorney with a reputation across the entire state for a specific, brutal specialty, dismantling the credibility of spouses in professions built on caregiving. Professions Corwin had learned, across a long career, juries and judges alike tended to romanticize right up until a skilled attorney reframed that same caregiving as evidence of naivety, of a person too soft-hearted to be trusted with clear financial judgment. Corwin's strategy in the Whitfield case followed a pattern he'd refined over 2 decades. He painted Claire gently and persistently, not as a villain, which would have been too obvious a tactic for a judge to fully credit, but as a fundamentally unsophisticated woman who had never truly understood or contributed meaningfully to the substantial wealth Marcus's real estate career had generated during the marriage. A caregiver by nature rather than a partner in building anything, entitled, under his careful framing, to considerably less of the marital estate than a full 50-50 division would suggest. Mrs. Whitfield is a wonderful nurse, Corwin told the court during one particularly painful hearing, his tone dripping with a condescension so smooth it barely registered as condescension at all. But nursing, Your Honor, while a noble profession, did not build Mr. Whitfield's commercial real estate portfolio. It did not structure his deals, negotiate his commissions, or build the relationships that generated the wealth this court is now being asked to divide as though both parties contributed equally to its creation. Claire's own attorney, a capable but considerably less experienced family law practitioner named Denise Okafor, fought back as hard as the evidence allowed, arguing, correctly, that Virginia law required an equitable division of marital assets regardless of which spouse's career had generated more direct income, that Claire's role managing the household, supporting Marcus's demanding schedule, and maintaining the stability that allowed his career to flourish constituted exactly the kind of contribution the law was designed to recognize. But Judge Harmon Pruitt, presiding over the case, seemed, across 8 months of hearings, increasingly persuaded by Corwin's narrative, a judge known throughout the local bar for a traditionalist streak that occasionally, uncomfortably, seemed to value a spouse's direct financial output over less visible forms of contribution. The cruelest moment of the entire trial, the one Claire would later say had nearly broken her resolve to keep fighting at all, came during a cross-examination in the 6th month of proceedings, when Corwin, pacing in front of the witness stand with the practiced patience of a man who had performed this exact routine dozens of times before, asked Claire to walk the court through a typical week in her nursing career. "So you work 3 12-hour shifts a week, Mrs. Whitfield," Corwin said, his tone gentle in a way that felt, to Claire, considerably more dangerous than open hostility would have. "That leaves quite a lot of time at home, doesn't it?" "For full days, in fact, most weeks. I also managed our household finances, coordinated every aspect of the homes we lived in during 2 relocations for Marcus's career, and maintained the social calendar that supported his client relationships," Claire said, keeping her voice steady despite the heat rising in her chest. "That work simply doesn't show up on a pay stub." "Of course," Corwin said, with a small, practiced smile toward the judge that made Claire's stomach turn. "Though I'd gently suggest, Your Honor, that maintaining a social calendar and running errands, however time-consuming, isn't quite the same category of contribution as structuring an $11 million commercial acquisition. The court shouldn't confuse busyness with building." Judge Pruitt had made a note on his pad without looking up, and Claire, watching that small, dismissive gesture from the witness stand, understood for the first time exactly how steep the climb in front of her actually was. The final hearing arrived on a gray Thursday in November, and Claire sat at the plaintiff's table in a simple navy dress, her hands folded tightly in her lap, watching Marcus across the room in a suit that had clearly cost more than her entire monthly salary, chatting easily with Corwin as though the outcome had already been decided somewhere outside the actual courtroom. Behind them, the gallery had filled with a handful of colleagues from Marcus's firm who had come, Claire suspected, less out of any genuine support, and more out of simple curiosity about how thoroughly their rising star was about to be vindicated in public. Judge Pruitt's ruling, when it finally came, was devastating in its thoroughness. He awarded Marcus the substantial majority of the marital estate, citing, in careful legal language that nonetheless landed like a series of small cuts, Marcus's role as the primary economic contributor to the marriage's accumulated wealth. Claire would receive the modest townhouse they'd purchased early in the marriage, a limited spousal support arrangement set to expire after 3 years, and little else, a ruling that effectively erased 8 years of a partnership Claire had believed, right up until the final gavel fell, the law would recognize as more than simply a transaction between an earner and a dependent. It was in the silence immediately following that ruling, with Claire staring at the table in front of her trying not to let 200 years of family stability and 8 years of her own life collapse visibly in front of a room full of strangers, that Marcus leaned toward Corwin, smirking, and whispered the 5 words that would echo through the rest of this story. "She never saw it coming." He said it just loud enough that the court reporter, seated close enough to catch it, would later confirm, without being asked twice, exactly what she'd heard. The heavy oak doors at the back of the courtroom opened 4 minutes later, not dramatically, not with any theatrical flourish, but with the slow, deliberate effort of someone pushing against a weight that had grown heavier with age. Eleanor Kessler walked down the center aisle in a wool coat far too warm for the mild November afternoon, moving with the careful, determined gait of a woman who had told her doctor, against his explicit advice, that she was leaving the house that day regardless of what her blood pressure numbers suggested she should do instead. She held a worn leather folder against her chest with both hands, the way a person holds something they have protected for a very long time, and do not intend to let go of easily. A young court clerk near the door half rose from his seat to intercept her, uncertain whether an elderly woman wandering unannounced into a just concluded proceeding required assistance or removal, but something in Eleanor's expression, a calm so total it bordered on formidable, made him hesitate long enough that she simply walked past him entirely. The gallery, still murmuring quietly over the ruling that had just been read, gradually noticed her, the whispers rippling backward through the room the way attention always seems to travel in a courtroom, row by row, until every eye had turned toward the small, determined figure making her way down the center aisle. "Your Honor," Eleanor said, her voice thinner than it once had been but carrying, nonetheless, an unmistakable authority through the quiet courtroom. "I apologize for the interruption. My name is Eleanor Kessler. I am Claire Whitfield's grandmother. and I believe there is a document relevant to these proceedings that this court has not yet had the opportunity to consider. Judge Pruitt, visibly startled, looked toward the bailiff with the particular irritation of a man whose carefully delivered ruling had just been interrupted before the ink had even finished settling. Ma'am, this courtroom is in the final stages of a concluded matter. Unless you are counsel of record, I'm afraid. I understand this is unusual, Eleanor said, not raising her voice, simply continuing forward with the same unhurried determination that had carried her through 6 decades of building something out of nothing. But what I am holding is a properly executed and notarized estate document that directly affects the character of certain assets this court has just divided as marital property. I believe, respectfully, Your Honor, that you'll want to see it before this ruling is finalized rather than after. Corwin was on his feet immediately, sharp and irritated. Your Honor, this is wildly improper. There has been no motion to reopen these proceedings, no notice provided to opposing counsel, no. Mr. Corwin, Eleanor said, turning toward him with a calm that seemed, somehow, to make the courtroom's temperature drop several degrees. I have spent 60 years reading people who talk quickly to avoid being asked hard questions. I would simply ask the court's patience for 5 minutes before you decide whether my document matters. Judge Pruitt, caught between his own irritation and a lifetime of legal training telling him that dismissing a properly executed estate document, without even reviewing it, invited exactly the kind of appellate reversal that damaged judicial reputations, finally exhaled and gestured her forward. You have 5 minutes, Mrs. Kessler. This had better be relevant. Eleanor approached the bench and opened the leather folder, withdrawing a formally bound document, its pages slightly yellowed with age, a notary's seal pressed clearly into the final page. This is my last will and testament, Your Honor, executed and notarized 4 years ago, well before the events that led to these divorce proceedings. I would direct the court's attention specifically to Article 7. The judge read in silence for a long moment, his expression shifting slowly from irritation to something considerably more careful. This establishes an irrevocable trust, he said finally, looking up, structured to activate specifically upon the dissolution of Claire Whitfield's marriage, naming her as sole beneficiary of your entire estate, with an explicit provision excluding those assets from any marital property classification. That's correct, Your Honor, Eleanor said. What the court may not yet be aware of, because it has never before had reason to review my estate planning, is that a portion of the funding Mr. Whitfield used to launch his commercial real estate practice 8 years ago, the initial capital that allowed him to leave his previous firm and start independently, came directly from a loan I personally extended to the couple as a wedding gift, structured at the time as a gift to both of them jointly, but documented, very specifically, in a promissory note that names Claire and Claire alone as the responsible party for its eventual repayment or forgiveness. The courtroom had gone very quiet. Marcus, still seated at the plaintiff's table, had gone pale in a way that made Corwin turn to look at him with open, unhappy confusion. In effect, Eleanor continued, her voice steady despite its thinness, a substantial portion of the seed capital this court just credited entirely to Mr. Whitfield's own economic contribution during this marriage actually originated from an asset legally belonging to my granddaughter alone, structured that way deliberately, years before I ever suspected it might matter this directly. I don't believe this court intended to award Mr. Whitfield credit for capital that was never legally his to begin with. Marcus stood up so abruptly his chair scraped loudly against the floor. This is insane, he said, his earlier smirk entirely gone, replaced by something considerably more panicked. That loan was a wedding gift. Nobody ever mentioned a promissory note. Claire never said anything about. Because Claire didn't know either, Eleanor said, turning to look at him directly for the first time, her expression carrying decades of quiet, careful patience finally, fully spent. I structured it that way on purpose, Marcus. Not to deceive my own granddaughter, but because I have watched enough marriages in my long life to understand that the people who need protecting rarely know they need it until it's almost too late to arrange. I didn't do this because I distrusted Claire. I did it because I never fully trusted you, not from the very first week I met you. And I decided quietly a long time ago that my granddaughter deserved a safety net woven so carefully into the fabric of things that nobody, including her, would even know it was there until the day it mattered. Corwin, recovering some of his composure, stepped forward. Your Honor, even if this document is authentic, and I have serious questions about its provenance, a wedding gift, structured however cleverly after the fact, was still understood by both parties at the time as a joint contribution to this marriage. This is, at best, a matter for a separate civil proceeding, not grounds to reopen a finalized divorce ruling. Mr. Corwin, Judge Pruitt said, setting the document down slowly, I have presided over family law matters in this county for 19 years. I am well aware of the difference between a genuine joint gift and a carefully structured personal loan disguised as one at the time to avoid exactly this kind of awkward conversation at a wedding. This document is properly notarized, dated years before these proceedings began, and drafted by an estate attorney with no conceivable motive to fabricate anything on Mrs. Kessler's behalf. He looked over his glasses at Corwin with an expression that had shifted, entirely and permanently, away from the sympathy his ruling had shown Marcus only minutes earlier. I am ordering this matter reopened for a supplemental hearing. I want a full accounting of the original loan documentation, verified by this court's own forensic examiner, before any final division of assets in this case is considered settled. The room, which had been holding its collective breath since Eleanor first walked through those doors, exhaled all at once, a low murmur of astonishment rippling through the gallery. Claire, still seated at the plaintiff's table, turned slowly to look at her grandmother, tears finally spilling over, though these, unlike the ones she'd been fighting back for the better part of 8 months, carried something closer to disbelief than grief. Grandma, she whispered, as Eleanor made her way carefully to the table and sat down beside her. How long have you known? How long have you been carrying that? For years, Eleanor said softly, taking her granddaughter's hand in both of hers, the way she had 1,000 times before across a kitchen table neither of them had touched their tea at. Since a week before your wedding, when I looked at that man's smile and decided, quietly, that I would rather be wrong about him for the rest of my life than right about him without having protected you first. The supplemental hearing that followed, spread across the next 6 weeks, unfolded very differently from the original proceedings. In the days immediately after Eleanor's courtroom entrance, Claire sat with Denise Okafor in her cramped downtown office late into the evening, the two of them poring over old financial records neither had thought to request during the original discovery phase, because neither of them had ever had reason to suspect the seed capital behind Marcus's independent practice traced back to anyone but Marcus himself. If your grandmother's promissory note holds up, Denise said, spreading a decade-old loan document across her desk, it doesn't just protect her estate going forward. It changes the entire story of how this marriage actually built its wealth. 8 months of Corwin's narrative, the self-made visionary, the caregiver spouse who contributed nothing measurable. All of it was built on an origin story that was never entirely true to begin with. She looked up at Claire, something like cautious excitement breaking through her usual careful composure. We need his firm's early records. If he described this money as family capital anywhere in writing, before he had any reason to lie about it, that's not just corroborating evidence. That's the whole case. The court's forensic examiner confirmed the promissory note's authenticity beyond any reasonable question, along with a detail Eleanor herself had not fully anticipated when she first walked through those courtroom doors, that Marcus's firm's own early financial records, subpoenaed as part of the supplemental review, showed he had explicitly described the loan in an early business plan document as capital provided by his wife's family, language he'd used enthusiastically to investors seeking reassurance about his financial stability in the firm's first 2 years, before quietly, deliberately, dropping any mention of it once his own success made the acknowledgement feel, to him, unnecessary. That single detail, a document Marcus had written and signed himself years before any divorce was on the horizon, transformed the entire character of the supplemental hearing. Corwin, watching his own client's early business plan directly contradict the very narrative he'd spent 8 months building, found himself in the uncomfortable position of arguing against evidence his client had personally generated in a moment when he had every incentive to be truthful and none to lie. He attempted, in the hearing's second week, to argue the document was an informal characterization rather than a legally meaningful admission, a position Judge Pruitt dismantled within minutes by simply reading the relevant paragraph aloud to the courtroom in its entirety. Marcus's own confident, boastful language about his wife's family backing making the argument that it meant nothing sound, even to Corwin's own visibly uncomfortable expression, considerably weaker than it had on paper. Judge Pruitt's revised ruling, issued at the conclusion of the supplemental hearing, reflected an entirely different understanding of the marriage's true economic history. The original capital, now properly credited as originating from Claire's family rather than Marcus's independent resources, shifted the entire foundation of what counted as marital contribution versus pre-existing, protected asset. Combined with a formal recognition of Claire's substantial non-financial contributions across 8 years, contributions Denise Okafor had argued passionately from the very beginning without ever quite landing with the same weight the forensic evidence now carried. The revised division of assets moved dramatically in Claire's favor, awarding her not just the townhouse and modest support she'd initially received, but a substantial share of the commercial portfolio Marcus had built, portfolio the court now recognized had been launched, in its earliest and most fragile years, on capital that was never fully his to claim credit for alone. Marcus's reaction to the revised ruling was, by every account from those present, considerably less composed than his earlier smirk had suggested he was capable of. He was heard, in the hallway outside the courtroom following the final hearing, shouting into his phone at Corwin about incompetence and malpractice, threats that went nowhere once Corwin's own careful documentation of his repeated, ignored warnings about the risks of overconfident courtroom theater surfaced during a subsequent bar complaint Marcus filed and ultimately lost. His firm, watching the very public unraveling of a case that had, for 8 months, painted its founding partner as a savvy, self-made success story, quietly distanced itself in the months that followed. 2 of his largest ongoing deals fell through when clients, uncomfortable with the sudden scrutiny surrounding his personal finances, opted to work with competitors instead. A profile piece the Regional Business Journal had been preparing for months, tentatively titled Whitfield's Rise, was quietly shelved entirely once the reporter working on it caught wind of the supplemental hearing, replaced instead, 6 months later, by a considerably less flattering piece examining the ethics of concealing family-funded seed capital in commercial real estate ventures, a piece that used Marcus's own name only twice, but that everyone in the regional industry understood immediately who it was describing. Ashley Bourne, the associate whose affair with Marcus had triggered the divorce in the first place, found her own position at the firm increasingly untenable as the scandal unfolded around them both. She had believed in the earliest months of their relationship, Marcus's private assurances that his marriage had been effectively over for years before she ever arrived, only to watch, with a slowly dawning horror, she confided to exactly one trusted colleague, the same confident, reassuring version of events reveal itself, piece by piece through the trial, to have been performed for her with precisely the same practiced ease Marcus had once performed devotion for Claire. She left the firm entirely within the year, a departure that came, according to colleagues who spoke about it only in careful whispers, considerably less amicably than either of them had likely imagined it would when their relationship first began. And she did not attend the small gathering Marcus's remaining friends organized to console him after the revised ruling, a detail his old friends noted, quietly, without ever saying so directly to his face. Claire, in the months following the revised ruling, did something that surprised even Eleanor, who had spent 4 years quietly protecting a granddaughter she'd assumed, right up until the moment she needed to be strong, might need considerable time to rebuild any real confidence at all. Instead, Claire returned to nursing with a renewed fierce focus, eventually using a portion of her settlement to fund an advanced practice degree she'd set aside years earlier when Marcus's schedule and social expectations had made the idea feel, at the time, impractical to pursue. The program was demanding in a way that left little room for the quiet grief Claire had expected to need to work through slowly, and she found, somewhat to her own surprise, that the exhaustion of clinical rotations and late-night coursework left less space than she'd feared for dwelling on 8 years she'd once assumed would define the rest of her life. Her classmates, most a decade younger and entirely unaware of the courtroom drama that had briefly made her name recognizable in certain regional legal circles, simply knew her as the sharp, unusually calm woman in the back row who never seemed rattled by even the most difficult clinical scenarios. A calm Claire herself understood, quietly, had been forged in a courtroom rather than a classroom. She also did something else, something that mattered to her every bit as much as the financial vindication had. She sat down with Eleanor one Sunday evening, the two of them at that same kitchen table where a warning about charming men had once gone unheeded, and asked her grandmother the question that had been sitting quietly between them since that courtroom door first opened. "Why didn't you ever tell me?" Claire asked. "Any of it. The will, the loan structure, any of it. I understand why you protected me. I just don't understand why you protected me in secret." Eleanor considered the question carefully, the way she considered most things, with the patience of a woman who had spent 60 years learning that the right answer rarely arrived quickly. "Because if I'd told you," she said finally, "you would have spent every day of your marriage wondering whether I was right about him, watching for proof, unable to simply live your life and find out the truth on your own terms. I didn't want to hand you my suspicion, Claire. I wanted to hand you protection, quietly, in case my suspicion ever turned out to be justified, without ever once making you carry the weight of it while you were still hoping, with your whole heart, that it wouldn't be." She squeezed her granddaughter's hand. "A grandmother's job isn't to tell you who to be afraid of. It's to make sure that if you're ever hurt anyway, there's already something solid waiting underneath you before you even know you'll need it." 2 years after the revised ruling, Claire completed her advanced practice degree and opened a small pediatric clinic of her own in a part of the city that had, for years, lacked reliable access to specialized care for working families who couldn't easily travel across town for appointments. She named it, deliberately, quietly, without any grand unveiling or press release, the Kessler Family Clinic, a name that meant nothing to most of the patients who walked through its doors and everything to the two women who understood exactly what it represented. Eleanor, well into her 80s by the time the clinic opened, insisted on attending the ribbon cutting despite her doctor's continued, gentle objections, sitting in a folding chair near the entrance in a wool coat considerably more appropriate for the actual weather this time, watching her granddaughter cut a ceremonial ribbon with the same quiet, unshakable pride she'd carried into that courtroom years earlier. "You know," Eleanor told her that afternoon, watching families begin filing through the clinic's doors for its very first day of appointments, "your grandfather and I opened that hardware store with considerably less confidence than you're showing today. We didn't know if it would work. We just knew we couldn't stand the idea of not trying." "I learned that from you," Claire said. "Even the parts one didn't know about until a courtroom door opened 4 minutes too late to stop a ruling that should never have happened in the first place." Eleanor laughed, a real, genuine laugh that still carried, even at her age, some of the same steel that had once carried a small hardware store into a regional chain of 11 locations. "4 minutes late is still on time, dear," she said. "As long as you walk through the door before anyone finishes signing anything permanent." Later that same evening, after the clinic's first patients had gone home and the small ribbon-cutting crowd had dispersed into the cooling autumn dusk, Claire drove Eleanor back to the colonial house where this entire story had quietly begun years earlier. The same kitchen table still sitting in the same corner it always had. Eleanor moved slower now than she once had, leaning more heavily on Claire's arm than either of them wanted to acknowledge out loud, but her eyes, watching her granddaughter unlock the front door, held the same sharp, patient attention they always had. "I want you to promise me something," Eleanor said, settling into her usual chair at the table while Claire put the kettle on out of habit, neither of them particularly planning to drink whatever tea eventually steeped. "Not about money. About watching. The way I watched you, all those years, without ever saying a word until it mattered." She paused, choosing her next words with the same careful deliberation she'd once brought to a courtroom she'd never expected to walk into. "Pay attention to the people you love, Claire. Not with suspicion. With attention. There's a difference, and it's the only inheritance that actually matters in the end." Claire sat down across from her, the kettle beginning its slow climb toward a boil neither of them was in any hurry for. "I will," she said. "I promise." And that is the whole story. A man who smirked at the exact moment he believed he'd won everything, without ever once understanding that the true foundation of what he'd built had never fully belonged to him at all. A grandmother who spent 4 quiet years protecting a granddaughter who had no idea she needed protecting, carrying a folded piece of paper the way some people carry a promise, patiently, silently, until the precise moment it would matter most. And a courtroom door that opened just 4 minutes after a gavel fell, proving, in the most public way imaginable, that some victories are never as final as the person celebrating them believes. If tonight's story moved you, I want you to remember one thing before you go. The people who love us most rarely announce the ways they're protecting us. Sometimes the safety net beneath your life was woven years before you ever needed it, by someone who loved you quietly enough to prepare for a storm they hoped, with their whole heart, you'd never actually face. If you enjoyed this story, smash that like button. It genuinely helps this channel reach more people who love a reveal exactly like this one. And here's my question for you tonight. If you were Eleanor, would you have told Claire about the protective trust from the very beginning? Or do you think her silence, and the timing of that reveal, was exactly the right way to handle it? Let me know in the comments below. Don't forget to subscribe and hit the bell so you never miss the next story. I'll see you in the next one.